Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications, exercise number 3 and 4 on the speed of 90 words per minute. Start. It is vehemently submitted by the learned advocates appearing on behalf of the state as well as the prosecutrix that the present case is not a case of mere breach of promise to marry, as contended by the learned senior advocate appearing on behalf of the accused. It is submitted that in the present case, from the very beginning and from the inception, the intention of the accused was not to marry with the prosecutrix, and he was to marry one another lady, Radhika Soni. It is submitted that despite the above, he called the prosecutrix at his residence, and by giving promise that he would marry, he had a sexual intercourse with the prosecutrix. It is submitted that in fact the prosecutrix initially objected to have any sexual intercourse. However, as the accused gave assurance and promise that he would marry, the prosecutrix gave consent. It is submitted that as the consent was obtained by the accused on misconception of fact, and therefore the same cannot be said to be a consent even considering Section 90 of the IPC, and the consent was on misconception of fact. Both the courts below have rightly held the accused guilty for the offence under Section 376 of the IPC. It is further submitted by the learned advocates appearing on behalf of the state as well as the prosecutrix that even the conduct on the part of the accused, which is borne out from the record, that when the parents of the accused and the prosecutrix subsequently met to fix the marriage, instead of remaining present, the accused ran away. It is submitted that it has come in evidence that the accused was already to marry one another lady, Radhika Soni, and therefore there was no intention on the part of the accused from the very inception not to marry the prosecutrix, and despite the same, by giving false promise to marry, he obtained the consent of the prosecutrix and had a sexual intercourse. It is submitted that therefore in the facts and circumstances of the case, it has been established and proved beyond doubt that the consent given by the prosecutrix was on misconception of fact, and therefore the same cannot be said to be a consent, and therefore the appellant accused is rightly convicted under Section 376 of the IPC. Learned advocates appearing on behalf of the respondent state as well as the original complainant prosecutrix have relied upon certain decisions of this court on Section 375 of the IPC, Section 90 of the IPC, and on consent on misconception of fact and on consensual sex, which will be referred to and considered hereinafter. Now, so far as the reliance placed on the decisions of this court relied upon by the learned counsel appearing on behalf of the accused, referred to herein above, learned advocates appearing on behalf of the state as well as the original complainant prosecutrix have submitted that none of the aforesaid decisions shall be applicable to the facts of the case on hand. Mr. Ramesh Singh, learned senior counsel appearing on behalf of the second respondent, has urged that the discrepancies which have been brought out in the course of the cross-examination of the former manager of the school would indicate that there is a doubt in regard to the authenticity of that certificate. However, in our view, what must weigh against the second respondent's submission is that the date of birth, which has been recorded in the certificate of the Saket Vidyasthali, completely matches the date of birth which was voluntarily disclosed by the second respondent both while obtaining his driving license as well as the Aadhaar card. In both those documents, the originals of which were seized during the course of the investigation and have been produced before this court, the date of birth is reflected as 17 December 1995. The driving license and the Aadhaar card are not stand-alone documents. The submission of the learned senior counsel that the date of birth in those documents may have been furnished by the accused to obtain an undue advantage cannot simply be accepted since it tallies with the date of birth indicated in the school records of Saket Vidyasthali School. It is evident from the above analysis that the date of birth which was forwarded in the roll of students of Ma Anjani Senior Secondary School, Kanpur, was the sole basis of the date of birth which was recorded in the matriculation certificate. The date of birth in the records of Ma Anjani Senior Secondary School, where the second respondent was a student from class 5th to class 10th, is without any underlying document, as stated by the principal in the course of the inquiry before the JJB. On the other hand, there is a clear and unimpeachable evidence in the form of the date of birth which has been recorded in the records of Saket Vidyasthali School, which is supported by the voluntary disclosure made by the records of Saket Vidyasthali School, which is supported by the voluntary disclosure made by the second respondent while obtaining both the Aadhaar card and the driving license. The High Court reversed the findings of the Sessions Judge purely on the basis of the matriculation certificate. For the reasons which we have indicated, the date of birth as reflected therein cannot be accepted as authentic or credible. Once we come to the conclusion that the date of birth of the second respondent is 17 December 1995, he was not entitled to the claim of juvenility as of the date of the alleged incident, which took place on 18 August 2015. For the above reasons, we allow the appeal and set aside the impugned judgment and order of the High Court dated 14 November 2018. Criminal Revision 2952 of 2017 shall in consequence stand dismissed. The order passed by the Sessions Judge confirming the decision of the JJB reflecting the claim of juvenility is accordingly maintained. The second respondent shall accordingly be dealt with in accordance with law on the basis of the finding recorded in the present judgment rejecting the claim of juvenility.